The broadcast is now starting. All attendees are in listen-only mode.
Good morning, everyone. This is Chia Halpern-Buetzel with the Tribal Law and Policy Institute, and I'd like to thank you all for joining and welcome you today to our webinar on the fiscal year 2017 OVW grants to tribal governments to exercise special domestic violence criminal jurisdiction. And I know this is being held a little late since the RFP is due next week, but we thought we'd just try to answer any possible questions and get some information out there to you. Today, Kelly Gaines-Stoner will be presenting. She's the Tribal Victim Advocacy Legal Specialist with the Tribal Law and Policy Institute. And I also neglected to put there that she is a judge for the Seminole Nation of Oklahoma. Today, she will be briefly going over the VAWA Title IX, which includes the Special Domestic Violence Criminal Jurisdiction, as well as going over the application for the grants to tribal governments to exercise special domestic violence criminal jurisdiction, some general grant writing tips, and we have it open for questions. So if you have any questions, please feel free to type them in on your little docking station there. It's the third from the bottom. So feel free to type those in, and I will interrupt Kelly as needed to ask questions, and then there's also time for questions at the end of the presentation. And today we are not going over the full range of information and resources needed. So again, if you have specific questions that we can't answer, please let us know and we can make sure we get those to folks at OVW or get you connected if there's very specific questions that we can't answer. And then we're not going over the full range of federal grant opportunities that could be used to fund VAWA implementation. There are some purpose areas under the CTAP application, and we will post a webinar on that within the next couple of weeks, and we'll get that announcement out soon. And then we're not going to do an exhaustive overview of the VAWA Special Domestic Violence Criminal Jurisdiction requirement today. Let's see, it looks like I have a question regarding the agenda. So this is, hopefully this will answer your questions for the agenda. And with that, I'm going to turn it over to Kelly.
Thank you, Chia. Will you be putting the PowerPoint up on the screen?
Oh, no, I'm sorry. I thought I had it. Let's see. Here I was going through it.
I thought it sounded familiar. No, I don't see it.
Okay, sorry, everyone. Let me see what's going on here.
There it is. There it is.
Is it up? Okay. All righty. Sorry about that. Thanks for letting me know.
You did a really good job on the slides. I don't think we need to go over those at all. So I'll go ahead and get started. I'll say hello to everyone out there. Again, thank you, Chia, for introducing me. And I just would reiterate what Chia said. Please note the deadline for getting this grant in. It is coming very, very quickly, January 25th of 2017. Hopefully you've already started to work on it. And Chia, do I have control of this so that I can move through this? Or would
let me turn it, let me give it to you right now.
Okay. So the first slide you see there up on your screen is a resource slide, and it's talking about implementation of the Violence Against Women Act. I think this one was of 2013, and what I really want you to pay attention to is the web address up at the top, because the National Congress of American Indians has a very rich resource with respect to VAWA, all the different versions of VAWA, and especially special domestic violence criminal jurisdiction. They have a great resource on it, and so does TLPI, the Tribal Law and Policy Institute. Did you give me control there? Because I'm pushing and nothing's happening.
I did. Let me try again. Let's see.
Okay.
I'll turn it to the next slide, and then I'll try to hand it over to you.
Okay. Thank you. Again, talking about the NCAI resources, and I'd also point out that the resources cover a variety of different topics that are related, directly linked to the Violence Against Women Act. You'll find resources on code development. You'll also find those on TLPI's website. There are some webinars that have been recorded by the nation's foremost experts on jury pool selection and how a sovereign goes about meeting the requirement of a fair cross-section of a jury pool. There are defendants' rights and criminal defense issues, of course victims' rights and safety, and you'll see those other resources there as well. Again, you'll find them on ncai.org and you will find them on tlpi.org. Chia, I think I might have to have you just move them for me. Okay, so when we talk about Title IX of VAWA 2013, we're going to focus, as Chia mentioned earlier, this is not an exhaustive, include everything sort of presentation. This is really directed towards the RFP that is currently out by the Office of Violence Against Women for issues related to special domestic violence criminal jurisdiction. It can be planning, development, and implementation. Any of those things that are related to special domestic violence criminal jurisdiction. So what this is all stemming from, the authority for all of this, is coming from this particular federal statute, Section 904, which recognizes a tribe's inherent criminal jurisdiction over non-Indians, and that's very important because this is not a grant of power from the federal government to the tribes. This is the federal government recognizing through federal law that tribes have always possessed this power. We've had some restrictions placed by federal common law, but this is releasing those restrictions on that tribe's power. And I want you to notice that it covers 3 crimes. Special domestic violence criminal jurisdiction recognizes this power of a tribe to hold non-Indian defendants criminally liable for committing the crimes of domestic violence, dating violence, and violation of a protection order that occur in Indian country. So I think that's really important that tribes are going to have to know what their Indian country is, and that's easy for some tribes, more difficult for other tribes. Tribes can exercise this special domestic violence criminal jurisdiction now as long as the tribe feels it can meet the mandates of the law. The Section 904 comes with a whole host of requirements or mandates by the federal law that the tribe must meet before exercising this jurisdiction. Currently, as of this date, the following tribes are implementing special domestic violence criminal jurisdiction and either are or will be prosecuting non-Indians for committing one of those 3 crimes we just talked about in Indian country if the mandates of the crime are met. And one of the requirements, we'll go over a few of those, one of the requirements is that the victim must be an Indian. So we'll go to the next slide. And I wanted to just mention, this presentation isn't about the Tribal Law and Order Act. This is a law that came before VAWA 2013, and this law, this federal law, actually loosened the federal restrictions placed on a tribal court sentencing authority in all cases prosecuted in the tribal court, all criminal cases prosecuted in the criminal court. And the federal law that loosened the restrictions, we call it TLOA, also had mandates with it that a tribe must meet before the tribe could begin to exercise this enhanced sentencing authority. So you can kind of see the TLOA purposes there. I don't want you to get this confused with special domestic violence criminal jurisdiction, but they are related, and the chart we're going to look at in a few minutes has the requirements for both. So you can kind of look down through there and see what the purpose of TLOA meant. It came after many hearings and meetings and listening sessions where the federal authorities were listening to tribal folks from Indian country, tribal governmental leaders, tribal law enforcement, tribal judges, the whole gamut, and then this law came into being. So what we have now is for those tribes in the United States of America that can, I should say federally recognized tribes with tribal courts, that do exercise criminal jurisdiction, they now, if they can meet the mandates of this TLOA, we're going to go over those in a few minutes, they can now sentence a criminal defendant convicted in tribal court from 1 to 3 years of imprisonment, a $15,000 fine, or both, and tribal prosecutors can stack sentences, if that's possible, based upon the fact pattern, but the stacking, the maximum stack, cannot exceed 9 years. So the defendant theoretically could be put in a tribal detention facility or detention facility used by the tribe for up to 9 years. And here's this wonderful chart. I've always found this very, very helpful. And what you see are the requirements in TLOA in the first category and the requirements of special domestic violence criminal jurisdiction in that second category. And you'll find one of the things that you're going to see is that these are very similar. Chia, I just don't know what I did, but I lost everything. So hang on. Pardon me, folks, as I try to get back to where I was.
So while Kelly's doing that, I just want to just make a note of the due process protections that are required by both, on this part of the chart, it's required by both the Tribal Law and Order Act Enhanced Sentencing and the VAWA Special Domestic Violence Criminal Jurisdiction. And so that includes that defendants have the effective assistance of counsel, which is equal to that guaranteed in the U.S. Constitution, and that tribes provide to indigent defendants a licensed attorney, and that defense attorney is also licensed by a jurisdiction that applies appropriate licensing standards and ensures professional responsibility and competence of those attorneys. Both also require that a judge presiding over the criminal proceedings have sufficient legal training for criminal trials, and that those judges are licensed to practice law by any jurisdiction in the United States.
Okay, I think I've got it here. Do you want me to take over, or do you want to finish those slides, Chia?
You go ahead. Okay.
You'll also notice we're continuing on with some of the federal mandates that are going to require that are required before the tribes can exercise VAWA 2013 Special Domestic Violence Criminal Jurisdiction. We've listed them on this chart here. We don't necessarily have to go over all of them, but note that the RFP that is going to fund this particular grant program also has these very same requirements. So this might be a nice tool for those of you who are writing the grant, just to cross-check that in fact you've checked your code. If there are code modifications that need to be made, you've noted those, and that you can also convey to the reader that you do understand what all of the requirements are here, and then discuss the steps that you're going to take to meet those requirements. So when we talk about potential area of need, we've listed those out in the chart, but here are some to really, we put them in a list here as well. Effective assistance of counsel for defendants. So this has been an issue, and what this really is going to mean is that people that are charged with crimes in tribal court are going to have to be able to, if they're indigent, if they reach a, and the tribe gets to define who's indigent and who's not, but if the criminal defendant is indigent, that the defendant shall be provided at no cost to the defendant, so the tribe's going to have to pay for it, a defense attorney. And hopefully that defense attorney would come with a set of credentials that would demonstrate that the defense attorney had experience and was properly trained to represent criminal defendants. Also, law-trained judges now are going to be needed for VAWA 2013, and those judges that are going to preside over these cases, these special domestic violence criminal jurisdiction cases, are going to have to be able to demonstrate their credentials as well, and those credentials can include experience. That the tribe's code is available, their criminal laws and rules are publicly available. That's taken many different forms as tribes have begun to implement this special domestic violence criminal jurisdiction, from being available online, which is the most common, to being available in a variety of different places for the public to come in and copy. Also recorded, the criminal proceedings must now be recorded. That does not mean you have to have a court reporter. It means that, and oftentimes it will just mean that you're going to have some sort of reliable audio system in there that is recording everything that's being said in the court. It's also a little reminder to judges out there that it's important to actually speak to the record and not instead make motions or mumble. People are going to have to speak up clearly. Jury pool selection, which has been a hang-up for some tribes, caused some tribes to be troubled by this, because the jury pool selection in your tribal community most likely will have to include non-Indians if within your Indian country non-Indians are residing, if you're finding them residing there, which is true in most instances. So that has to happen. We need training for law enforcement. You have to think about where you're going to put this non-Indian that you're prosecuting in your tribal court. If you're meeting all these requirements, where will they be held? Do you have probation? Who will pay for the health care of this non-Indian? Is there a plan for that? Will you, in fact, if you're at the very beginning stages, if you're a tribe and you're thinking, well, we would really like this, and this is definitely an issue in our Indian country, one of the ways you can think about going about and implementing special domestic violence criminal jurisdiction is by creating a domestic violence court that is a court that is uniquely designed, and the staff is trained, meets all the requirements of special domestic violence criminal jurisdiction, and so perhaps only the defendants, criminal defendants who go over into the special court are getting all of these particular rights. Some tribal courts are giving, some tribes are giving these rights to all of their criminal defendants, but just another variation there. I'm a big fan of domestic violence courts, and if you can't do the entire court, to do a domestic violence docket, because I think they are more victim friendly, and where the criminal justice system is not, and I think also it focuses on victim safety and folks that are specially trained in the dynamics of domestic violence coming in contact with the victim and the victim's family. Code development might be another area of need. You need to really begin with your Constitution. Go in there and look to see if there's anything in that Constitution that conflicts with the tribe exercising criminal jurisdiction over non-Indians. If so, constitutional changes sometimes take more time, they're more expensive, sometimes they take a vote of the people. That's the first place I like to start. The second place is I like to start with the civil code, because one of the 3 crimes is violation of a protection order. Is there anything in your civil code that says that you can only issue protection orders in matters involving Indians? Because that would have to be changed then if you're going to be able to prosecute a non-Indian for violating a protection order in Indian country. So be thinking about those sorts of code development issues. If you're going to include a prohibition on a defendant who is subject to protection order carrying a firearm. And also, this is a great time for tribes who don't already have victims' rights addressed in their tribal codes to go back and look at victims' rights and putting those in the code so that the victim feels more empowered and has some rights as well as this criminal case proceeds. And there's a great resource, victimlaw.org. You can get on, so you can type in, you can search it by topic, victims' rights topics, or you could search it by tribe or state. All of the tribes that have digitized codes, their victim rights provisions are located on that website. So you can kind of look and see how other tribes have done it to see if that's what you're, what you're thinking of for your court. So as we move on to this particular RFP, you see some language popping up on the slide here to talk about what this particular RFP is really trying to focus on, and it is to assist tribes in getting to where the tribe is in the position to meet the mandates to exercise special domestic violence criminal jurisdiction. And this is saying that these grantees will receive support and technical assistance for planning, developing, and implementing their criminal justice systems with respect to this special domestic violence criminal jurisdiction. It's interesting to note that this language here says that how important it is to get collaborations of tribal leaderships, tribal courts, tribal prosecutors, tribal attorneys, tribal defense, law enforcement, probation, service providers, and I would think that would be both victim service providers as well as batterer intervention type programs, and other partners to be sure that we're holding batterers accountable, non-Indian batterers accountable, but we're also doing it in a very responsible way systemically. And all the systems work together. And I think you're going to find later on in the RFP that is going to be a requirement that you demonstrate the resolution and the MOU, that you demonstrate that you are working with all these different systems. The timeline we've been talking about, the RFP came out December the 8th of 2016. It was a pretty short window, closes on January 25th, 2017, and it's OVW anticipates notifying all applicants of funding decisions by October 1, 2017. Here is the scope of the program. It's determined by statutes and regulations as well as OVW policies. And just pointing out that if you are selected if you apply and you're selected as a grantee, the grant is awarded, you're agreeing that you'll follow the DOJ financial guide. And I think the RFP has a live link to that guide as well, which is updated from time to time. Here are the purpose areas of this particular RFP, and if you'll look down through those, this again kind of goes back to that partnership piece we just talked about. It's just this is to strengthen tribal criminal justice systems, and that includes law enforcement. It can spill over into the court, the tribal prosecutor's office, your appellate court systems, your probation systems, your detention facilities, rehabilitation centers. It spills over into the victims' rights area for culturally appropriate services and assistance for victims and their families, and certainly going to look at your criminal codes. And I think you're going to have to take a look, as I said, at your Constitution and your civil codes as well with respect to issuing protection orders. More purpose areas: to provide these non-Indian defendants with effective assistance of licensed defense counsel at no cost in criminal proceedings where this non-Indian is being prosecuted for one of those 3 crimes covered by special domestic violence criminal jurisdiction. Also, it's going to require the tribe to put in place a system for summonsing, for bringing possible jurors in, if you're going to have, on a jury trial day, that you're summonsing in a cross-section of your tribal community. And again, the NCAI website has some wonderful webinars recorded on that very issue, how you go about that. And also TLPI and NCAI offer technical assistance on that issue, as well as the National Center for Juvenile and Family Court Judges. The last purpose area is to accord victims of DV, dating violence, and violations of protection orders, those 3 crimes, rights that are similar to the federal victims' rights crime. That's the number you're seeing there. So you can actually Google that, and those victims' rights will come up as well. Don't forget victimlaw.org as well, because that is a very user-friendly website that you can find those victims' rights on as well. Some mandatory requirements of this particular RFP. You must submit, along with the other application parts, a tribal resolution that, so you must submit that, and that resolution needs to indicate that the tribal government is engaging tribal leaders and this whole list of systemic representatives here, prosecutors, defenders, tribal attorneys, that all of these system partners are going to work together. They're going to cooperate to implement this grant, because you see that it might take some code revisions, it might take some training, it might take some changes in the way the criminal court is currently being run, all of those things. That's why this resolution is being required. Also, the tribe that's applying must have submit a memorandum of understanding, or an MOU, that also includes these necessary internal and external partners. Now, you can add partners to this, but the previous slides have indicated who those essential partners are. And it says if any of the required partners, such as the tribal court or the victim service providers, are not subject to the authority of the tribal governing body, you must explain that in the MOU. You must explain it. And they give you an example in the appendix. So you're going to have the resolution, and you're going to have the MOU. If you don't have those things, that will kick you out. You won't be considered for funding. So those are incredibly important documents. So some mandatory requirements if you are awarded the grant. The tribes that are awarded, they're agreeing to become a member of the Intertribal Working Group, which is called the ITWIG, on Special Domestic Violence Criminal Jurisdiction. It's voluntary, and it's all the tribes that are working towards implementation and the technical assistance providers. We have monthly calls. I believe the tribal judges have their own call, and then everyone else has a separate call where the latest issues in implementation are fleshed out, where tribes that have already implemented or are near implementation share their forms. It's very resource rich, so that is just a great group to belong to in any event. So this is a requirement of this grant if you receive funding under this. Even if you don't, it's free to join, and it's a great resource. Prior to approval of an exercising of special domestic violence criminal jurisdiction, OVW will assess the tribes that receive this funding, will look at your packet, much like that was done for the pilot programs, and look at your statutes, see if there are any glaring conflicts, and you'll have to fill out a questionnaire and supporting certifications, much like the pilot project tribes filled out. And so you will be working with OVW on any issues that seem deficient. You'll be getting some technical assistance to help you with those. And by you, I mean tribes that have received the award. So there are some activities that compromise victim safety and recovery that really should not appear in your grant. And I'll just say that some victim service providers are tasked with drafting portions of the grant and looking those over, and then other tribes might be using a grant writer that really doesn't have experience working in the domestic violence, sexual assault, and stalking field. So I would definitely want someone, your victim advocate, someone with that sort of experience to look through your grant proposal to make sure none of these compromising activities, victim compromising activities are present in your grant. So you can kind of read down through there what they are. Yes, they go on, and really important, they're all very important, but please take note at number 13, requiring that victims bear the costs associated with the prosecution of these crimes, any filing to get a protection order, any costs associated with serving of that protection order. That is all prohibited. And one other thing I want to say, look at number 9, because I still see this. It is not acceptable to utilize anger management classes instead of court-ordered batter intervention programs. Anger management classes are that is a victim compromising activity. You instead need to have, it's usually, I think, recommended 52-week court-ordered batter intervention programs, and possibly even a few sanctions. What's going to happen if that batter doesn't attend 52 weeks? So be really, this is a great conversation to have with your victim advocates. Some more out of scope activities, not that these don't all have to be victim compromising, but out of scope for this particular RFP. Research projects, prosecuting cases of sexual assault that do not involve spouses, intimate partners, and dating partners. So that intimate relationship is a requirement for this particular proposal. So this is going to be stranger rape kind of prosecutions. Prosecuting cases that do not involve domestic violence, dating violence, or violations of a protection order, because special domestic violence criminal jurisdiction only covers those 3 kinds of cases. You may not purchase or lease a vehicle. And I think this is it's underlined here, very important to look. We talked earlier about, well, if the tribal court prosecutes a non-Indian defendant and the non-Indian defendant is found guilty and sentenced to incarceration, who is going to be responsible for paying the health care of that non-Indian, because IHS will not cover it. So if you're using a detention facility that's located within a state and you're contracting for that, do they have an insurance policy that's going to cover that non-Indian? If not, the tribes are going to have to find a way to cover that particular health care by seeking out insurance policies, seeking out any other options that you might have to cover that non-Indian defendant's health care. And in the grant proposal, the applicants may not allocate more than 10% of the funds to request medical services for these incarcerated non-Indian individuals. The grant award period is approximately 36 months. Again, we already said it would begin about October 1, on or about October 1, 2017. OVW anticipates that the awards will be made for up to $450,000. It might be a little less for some grantees. The tribal jurisdiction program typically makes awards in the range of $300,000 to $450,000, and again, that's for 36 months. And OVW estimates, their best estimate is that they will make up to 5 to 7 awards. The total they have to award is $2,200,000. In 2016, just last year, 10 tribes applied for this particular grant, and 7 tribes were awarded funding. Awards will be made as cooperative agreements with OVW, and OVW expects to have ongoing substantial involvement in these award activities. We've gone over some of those. The OVW grantee will be actively participating in the ITWIG. We've gone over that. OVW will be reviewing legal materials that this grantee is developing towards implementation of special domestic violence criminal jurisdiction. They're going to be taking a look to see if the tribal code and tribal practice is equating to trial by an impartial jury. They're going to be looking for effective assistance of counsel, indigent defense counsel, looking at the judges' qualifications or how the tribe is deciding which judges are qualified. They're going to be checking this whole list here. So know that going in, that if you get the funding, OVW will be there working with you to hopefully bring everything up to standard to meet the mandates of the federal law. OVW will accept applications for this funding from new applicants only. Applicants, grant recipients that received this funding in 2016 are not eligible to apply. So only new applicants that have not received the special domestic violence criminal jurisdiction funding in 2016 can apply. Eligibility requirements are all here. Indian tribal governments that have jurisdiction over Indian country, and the definition of Indian tribal government is there. And there's the federal definition of Indian country. OVW is not limiting eligibility for the tribal jurisdiction program to tribes that are already exercising or prepared to exercise. In other words, if you're a tribe and you're already exercising special domestic violence criminal jurisdiction, but you did not receive funding in 2016, you are eligible. If you meet the other requirements, you're eligible to apply for this. Or if you're a tribe that's right on the cusp of implementing special domestic violence criminal jurisdiction and you did not receive funding in 2016, you're also available. I think the OVW is saying here they're going to look at all applicants and tribes that are at varying stages of development with respect to special domestic violence criminal jurisdiction. They're going to take a look at all of them. This selections will be made by a peer review selection process, which is very normal for OVW. And this sheet simply tells you the number of points each of the required sections of the application are going to be given. Make special note of project narrative. It is worth 65 points. That is a huge chunk of the points. And it's made up of 3 different pieces: a description, project timeline, and who will implement. Don't forget the MOU is a requirement, and also that tribal resolution. So while you're planning and before you submit, if you are making a single file made up of separate attachments, a single file, but it's got separate attachments to it, do not submit the single file to OVW this way. It's important to use separate attachments of documents when you submit your application to OVW. And also, as a former peer reviewer, I can tell you it makes it so much easier to review these grants. You know, if you happen to drop one and you're peer reviewing and the papers get all shuffled around, you want to make sure you have page numbers on there, and that you label each attachment either in the header or the footer, the top of the page, the bottom of the page, so that the peer reviewer can clearly say, oh, I can identify which tribe this is and exactly what attachment this is, whether it's a resume, whether it's a job description, something like that. The summary data sheet, which we just said was a component, it has a page limitation. 1 to 4, but that does not count towards the 20-page limit. So don't worry about counting those 1 to 4 pages of summary data sheet into your overall 20-page limit. Project narrative, again, a big piece of the points system. And notice here, it's asking you the RFP is asking you for some very specific information about your particular Indian country. It's so important that you realize the peer reviewer may not be familiar with your tribe and your tribal communities. So this is an opportunity for you to talk about the geographic area, how large the tribal land base is, who lives there, who will be served there, the tribal strengths, resources, challenges, needs. And hopefully, if you're going to be writing for a grant that funds criminal prosecution of non-Indians, that's going to be one of the needs that your grant's going to be talking about there, and the tribe's current lack of ability to hold those offenders criminally accountable. Also, what kinds of services are available for your victims of domestic and dating violence? And how will victim safety and autonomy, how is that going to play in your implementation of this plan you have? And that's a huge piece. You know, don't overlook that. It can't be over 20 pages. And remember, the peer reviewer may not be familiar with the community. So you are telling the story of your tribe with respect to these topic areas. So explain it as if you were explaining it to someone who had never been there. Describe the criminal justice system, and the grant RFP is well written. It'll take you through each one of the different pieces they want to look at. We've talked about your code development, looking at that tribal constitution and your law and order code, and tribal court practices, and whether or not you have defense attorneys available for criminal defendants. They want to know, does your tribe exercise this enhanced tribal court sentencing we talked about earlier in the presentation, TLOA? And it's going to give you a whole list there of things that you really need to be sure you address. And you should print this off and check every time you put this in your proposal that you have thoroughly addressed it. And if something is missing, you don't have information, you don't have one of these particular pieces, then you should have a bullet and where it says tribal, let's see, availability of counsel for indigent defendants. You should put that bullet there and say, currently we do not provide counsel for indigent defendants, and explain why, whether it's a funding source or describe the project activities, the goals and objectives. How are you going to gather the data? Who's going to be responsible for that? Again, the page limit is there. And knowing that these goals and objectives really need to be tied to the need that you identified in your tribal community, what you're trying to accomplish, because the need tells us what you're missing, and the goals and objectives are going to say what steps are you going to take to address that need. A timeline is required. There's a template for you to use there. It's very compact, it's easy to use, and remember that your timeline needs to cover 36 months. 36 months. So don't put in and, you know, for just 12 months. It's got to cover 36 months. And there's a sample of the timeline. So when OVW provides you with samples, templates, it's really best to use theirs, because the peer reviewers are they've read the RFP, they've seen the templates, and then the peer reviewers are familiar with how it's supposed to look. Other attachments that you, as necessary to include, there's some, of course, the project abstract, which is, I think it's a 2-page summary, kind of just a summary if you weren't going to read the entire grant, that this would give you, kind of primes the peer reviewer for getting ready to delve into the details of your grant. All these other forms OVW provides in their appendix, so make sure that you have all of those. Common problems and biggest reasons for unsuccessful applications, applications that are not funded. If you don't respond to all the requested information. Let me just give you a piece of advice here, and I think it probably will come on down in the tips. Follow the outline of the RFP exactly. When it asks you for A, talk about A. Even if you think that you should have talked about C first, talk about A. Do it in the order of the RFP. Provide every single piece of information that that RFP is requesting you to provide. And if in fact you don't have it, you say, I recognize that the RFP is asking for this. This tribe does not have it, and here's why. And you might, if you have the plan for later getting it, you might put that in there as well. If you don't draw a connection between the need you identified, the issue, the problem, and the activities that you're going to propose. If you, nowhere in your proposal do you say there's a need to prosecute non-Indians for these 3 crimes in your Indian country when they're committed against Native women, and then all of your goals and activities have to do with that, you're missing a huge piece of it. So the need, and then how you're going to address the need. Again, following the RFP, the headings, making it easy to read for these peer reviewers who are sometimes reading, many proposals. And when you have writers doing different sections, I think that's really difficult. Not that it can't be done properly, it can, but it takes a lot more time because each writer has a different style, and the reader gets used to one style and then has to switch over to another, and sometimes there's a disconnect there. And also provide measurable targets for performance. If you are going to be given funding, how will OVW be ensured that you have met your goals? How will they know that? Draw that out. We will be able to do these 5 things. Read the solicitation carefully. Read it once without making any marks on it. It's always my suggestion. And then read it again and highlight and make notes all over it. No detail is too small, and no instruction in that RFP should be ignored. It's there for a reason and probably attached to some points. Check all the resources available through online OVW website. Again, they provide templates. Don't use one from several years ago. Get the fresh ones that OVW has made improvements to and that currently are making available to you with respect to this grant proposal. Don't wait until the deadline. This is not the type of proposal. This has so many moving parts to it. This isn't the kind of proposal that you can wait till the last minute to put on because you have to have so many different collaborators on this. Go back and review the project narrative because that's what makes up the most points. And then go back and review the budget, make sure, and have a second or third set of eyes look at these as well. You get used to looking at your proposal, and you even the most glaring errors don't jump out at you because you've become too close to it. So have fresh eyes take a look at it. I think we've already said that you need to plan ahead. The grants usually come out in November, February, and the award isn't until September or October, so know that. You can contact your grant managers. You can contact tribal technical assistance providers if you have questions or need some assistance. You can review online resources and prior proposals. You have a right to ask for the proposals of successful grantees. You can see what their grants look like. You can serve as a peer reviewer if you feel you have the qualifications, or you can conduct a mock peer review exercise. I think serving as a peer reviewer is one of the best ways to become a better grant writer. So if you're given the opportunity, I would urge that you take that on. And don't forget to register on grants.gov and the GMS as well. If you have applied and you did not get the grant, some tips for you. Always ask, if it was an OVW grant, ask them to provide you with the strengths and weaknesses comments that all peer reviewers put together. And then OVW summarizes all of those peer review comments that can be very helpful in you putting together a better proposal next time. Keep prior proposals and comments, although remember you're going to have a different review panel each time, and look for patterns in those comments from the peer reviewers. Ask the agency, in this case OVW, what other services can be provided. I know OVW has held some webinars, answered some, had open question and answer during the webinars. Ask if there's training and technical assistance. If you don't get the grant, that might be useful to you. Capacity building sorts of resources, scholarships for conferences and trainings if you aren't funded. And then again, I've already mentioned, ask for those successfully funded applications so you can look at those. And always ask for TA contact information, which OVW is ready to give. So we've gone over some tips. The deadline, obviously if you miss it, you're going to be out of luck. Focus on the scoring criteria. There is a huge chunk of it in that narrative, so think about that. Think of the RFP as a checklist. It is going to be your checklist. Use the scoring criteria as a guide as to how many pages you should devote of your 20 pages to each section. That 65 points ought to be 65% of your grant application. Always answer every question, even if you have to say, we cannot answer this question because. Address every issue. Use all available pages in most instances. Be sure you have all your attachments and that you're using the most current OVW attachments that are online. Follow all format directions. There are formatting directions that tell you the font size, where the page numbers need to go, all of that. Make sure you've done that. Think about that peer reviewer who's tired, sitting up there reading 10 grants, and you want that peer reviewer to pick your grant up and say, oh, this tracks the RFP. I can just go right down here and see where everything is. Have other people in your staff review and score it if you have time to do that. Always put things in a PDF so that things aren't going to be shifting around and formats aren't going to be changing as you send it. Always label things clearly and be thinking, that you want to be different, interesting, and that what you do can be replicated by other tribes, can be used by others. And with that, that concludes the presentation, and Chia would just ask you if we have any questions.
I don't see any questions right now. If anyone thinks of any questions, I should have put my email up there, but it's chia@TLPI, which is chia@tlpi.org, or you could email Kelly, KELLY@TLPI.org, and if we can't answer the question, we can get it to some folks at OVW, get you connected. I think even if you look on the RFP, there's another, I think there's a little worksheet or some kind of, I think it's a paper that's about 2 pages long, and it has contact information for Rebecca Jones, who is would be the grant manager for this program, and so she has her email address available on there as well. So if you have questions that we didn't answer or that you think of later, please feel free to contact us or to look online for Rebecca's email. And let's see. Oh, let me see if we have a question here. 1 second. Okay, the question is, can money up to the 10% be used to purchase health insurance?
Yes, I believe it said that the overall funding amount, the applicant can use up to 10% of that funding for health costs related to incarceration. Did that answer the question?
I think so. I don't see any other further questions. She said yes, thank you. Great. So if anyone, again, if you have any questions that you think of later, please feel free to contact us. And I thank you all for joining, and I will send out an announcement for a CTAS webinar that we'll be doing, and Trish Saxton from the Bureau of Justice Assistance will be joining us, and she'll be able to answer specific questions too about Bureau of Justice Assistance funding for implementing special domestic violence criminal jurisdiction, because there are a few purpose areas that can be used to fund these activities if you're not able to get funding under this grant. And then again, you know, if you get grant funding from both sources, that's even better. You know, more funding for your tribe to implement the special domestic violence criminal jurisdiction. But we'll be having a webinar within about 2 weeks, and I will get that announcement out shortly. So thank you for joining, and have a great day. Thank you, Kelly.